Hi, I'm Florida Foreclosure Defense Attorney Richard Shuster, and today's topic is, what does your firm do when a case gets noticed for trial? Well, generally, a case will be noticed for trial with at least 35 days notice. Most of the time, we have about 2 months lead time between receiving notice and the actual trial itself. As soon as we get a notice for trial, the first thing we do is send out trial-specific discovery. We send out interrogatories asking who will be the witness who will actually testify for the bank at trial. We send out requests to produce to get copies of the exhibits that the bank will actually use in the foreclosure trial. Why do we do this? Well, first of all, we don't want any surprises at trial. And second, if the bank shows up at trial with exhibits that were not produced or with a witness that was not disclosed, we'll move to exclude that witness or the exhibits and keep that person from testifying at trial. The next thing we do in many foreclosure cases is to notice the deposition of the corporate representative who will be testifying at trial. We'll bring that person to our office or to the county where the case is pending, and we'll ask them many of the same questions which we expect to be discussed at the trial. This way we get a preview of what their testimony is going to be and see if there are any gaps in their knowledge or if they have the actual foundation to prove the bank's case. The third thing we do when a foreclosure case is noticed for trial is to reopen lines of communication about settlement. We've had a lot of cases where at the beginning of the case the bank was really hesitant or resistant to talking about settlement. The bank thought they were going to win their case easily and that they wouldn't have to go to trial to win, that they would win by either default or summary judgment. And after a year or so of litigation, when they were unable to win by default and were unable to win by summary judgment, and they're faced with a trial that they could lose, many times the bank is a lot more open to settlement communications, and many of these cases will settle on the eve of trial when the bank knows that the homeowner's lawyer is prepared to go to trial and a reasonable settlement offer is presented to the bank. I'm Richard Shuster. Thanks for watching. If you have additional questions about foreclosure defense law, eve of trial techniques, or trial preparation for a foreclosure case, visit our blog, visit our firm website, give us a call, or email us at foreclosuredefenselaw@gmail.com. Thanks for watching. Is attempt to reopen lines of settlement communication. We've had a lot of files where initially the bank was reluctant to entertain any settlement offers, but on the eve of trial, faced with the possibility of